Good morning. It's Monday, April 6th, and I want to welcome you to McAfee Taft's ongoing discussion of the COVID-19 crisis and the issues that are being raised for employers and HR professionals. I want to make sure you're aware of our McAfee Taft COVID-19 Response Resource Center. You can find it at the McAfee Taft website at McAfeeandTaft.com. It's not only addressing employment issues, but also covers such subjects as employee benefits, tax issues, as well as business loan program information. If you go to our COVID-19 response resource page, you'll also have an opportunity to subscribe to our alerts that we issue, again, to address new questions and new issues as they arise. And you'll have the opportunity to receive our weekly COVID-19 digest, which is really a comprehensive view detailing new information that will be helpful to you, your employees, and your business. I'd like to introduce two members of the McAfee Taft COVID-19 response team, Neal and Jake Crawford. We wanted to talk about some new developments since our May 31st video that covered the Family First Act. After that law's initial enactment, we've had a series of DOL guidances that have tried to provide some direction to employers on how paid leave is intended to work for their employees. But on April 1st, the Department of Labor issued its first formal regulations on, again, the administration and entitlement of paid leave under the Family First Act. So Kathy, Jake, and I this morning are really going to focus on what new information or a new direction have come to light under these April 1 regulations. Let's recall what types of paid leave are available potentially for your employees. First of all, there are 5 categories of employees who may be entitled to paid sick leave. Category 1 would be employees who are subject to some governmental, that is a state or local or federal quarantine or isolation order. Category 2 would be instances in which an employee has been advised by a healthcare provider to self-quarantine. Category 3 would be employees you have who are actually experiencing COVID symptoms and are seeking medical care or diagnosis. Category 4 would be an employee you have who's caring for another individual, and that other individual is subject to a governmental quarantine order, a recommendation by a healthcare provider that they self-quarantine, and or someone who they're caring for somebody who has COVID-19 symptoms. And the 5th category under paid sick leave are your employees who have to care for an employee, have to care for a child because that child's school has closed or their child care provider is no longer available. Now, that paid sick leave for those 5 categories amounts to 80 hours of paid leave, 2 weeks of paid leave, and a proportional amount for part-time employees. Let's move to the expanded Family and Medical Leave Act leave that's provided under the Family First Act. One category of employee is entitled to that expanded FMLA leave, and that category are those employees, again, who are required to provide child care because their child's school is closed or the child's child care provider is no longer available. For that expanded FMLA leave, employees are entitled up to 12 weeks of expanded FMLA leave, the first 2 being unpaid. So the original act and later DOL guidances provided that employers in some instances who have less than 50 employees can seek an exemption for these paid leave requirements. So Kathy, what more did we learn from these April 1 regulations about which employers or which employees may be exempt from these paid leave provisions?
Well, first of all, a small business is defined as a business, a nonprofit, or a religious organization with fewer than 50 employees. And when the Family First Coronavirus Response Act first came out, I think there was some confusion among employers. I think a lot of small employers just assumed that they'd be able to apply for and qualify for this exemption under the Act, but we know now that it is very narrow in its scope. It only applies to employees who are pursuant to number 5, which you just listed, either caring for his or her child, or because school's closed, or because they don't have any child care, or who are seeking expanded FMLA leave for those child care reasons. So the exemption is not available for an employee who is suffering from his or her own quarantine order, or is self-quarantined pursuant to a doctor's order, or who's experiencing those COVID-related symptoms.
One question I had, let's assume you're dealing with this child care issues you talked about. The exemption for small employers, does it apply to all their employees, or how is that decided? Is it decided on an employee-by-employee basis?
It is on an employee-by-employee basis. So the small employer who, like I said, has less than 50 employees would have to determine that to grant the sick leave and expanded family and medical leave would jeopardize the viability of the business as a going concern, number one. So that has to be made by an authorized officer of the business. It can't just be your friend in the next cubicle making that determination. It has to be somebody pretty high up the food chain who is the authorized officer of the business. And that authorized officer has to determine that there are one of three factors present here. The small business would be entitled to the exemption if the leave requested is going to result in the business's expenses and financial obligations exceeding the available business revenue and cause the small business to cease operating at a minimal capacity. Now, that's number one. So that's really a business determination. Or the absence of the employee or employees who are requesting the leave is going to entail a substantial risk to the financial health or operational capabilities of the business because of the employee or employer's specialized skills or knowledge of the business or responsibilities. Or the third would be there aren't sufficient workers who are able, willing, and qualified, and who would be available to perform the labor or services that the employee or employees seeking this leave would normally provide. So the way this is written it leads you to believe that this needs to be determined on a request-by-request basis.
The employee-by-employee.
Yes.
Okay, now
Yes.
with the new regulations, let's assume you've had an employee make that request and the employer has concluded that request should be denied because it falls in one of the three categories you just told us about. What sort of documentation do the regs say an employer should make to protect themselves if they're going to deny an employee those leave rights?
Well, the DOL, number one, says we don't want whatever documentation you have. You keep it. And the reason you keep that is because you may have to justify claiming the exemption, or you may have to defend yourself if someone makes a claim or files a lawsuit against you. But the documentation, of course, needs to be in writing. I would suggest that you ask the employee to put the request in writing and that there be a response to that request. That could be via email. It could be via a memo to the file. But there needs to be a justification based on one of these three reasons for why the leave has been denied.
What advice do you give to employers about giving the employee that same written documentation or reason? Is that a good idea if they're going to deny that leave?
I'm a believer in being transparent with your employees. So, I think that if someone has asked for that leave and you have a legitimate reason for denying the leave, that you should tell the employee. Now, number one is a little bit different where you're analyzing your business expenses and your financial obligations and determining whether or not they exceed the available business revenues. So that's a little bit different than the other two, where you're looking at the absence of someone who's got specialized skills, or where there wouldn't be sufficient workers who are able to cover.
Okay, so let's shift now to another exemption. The Act provided that healthcare providers and emergency responders could be denied paid leave under the FFCRA, and that exemption or exclusion of healthcare providers or emergency responders, that applies to all types of leave, not just child care leave, correct?
It does. It's much more broad.
Okay. So I think we all know that doctors and nurses are healthcare providers. Did the regulations give us any more information of maybe some a broader group of employees that would be considered healthcare providers?
They do, actually. They give us quite an expansive list. So for someone to be deemed to be eligible for this exemption, the regs say it's anyone employed at, and it lists a number of places. We would be, obviously, doctor's office, hospitals, health centers are what we might expect that to be. But they also include, for example, nursing facilities, retirement facilities, nursing homes, any facility that performs laboratory or medical testing, a pharmacy, and the like. And it also includes persons who are the ones who provide services or who maintain the operation of the facility where those services actually support the facility.
So that might reach beyond the direct healthcare providers to people that are supporting the office or the provision of those services.
Right.
Okay.
Right. It goes on to actually include people who provide medical service or produce medical products as well.
Okay. So let's talk about emergency responders. Of course, it's easy for us to think about firefighters, police, ambulance, or emergency medical personnel. These new regulations, they talk about what sort of emergency responders that we might not think of originally as being exempt from paid leave.
They do. It would include the military or the National Guard, law enforcement officers, correction institution personnel, firefighters, 911, 911 operators, child welfare workers, public works personnel. So it's quite broad.
Jake, let's go to you now. Two of the qualifying events for paid sick leave concern whether an employee or someone they are caring for is subject to a quarantine or isolation order. Do these April 1 regulations really address whether Governor Stitt's executive orders and the orders that mayors around the state have issued, whether they trigger the paid leave in terms of a governmental order?
Yeah, and so that's a question we've been getting asked a lot. Which of these orders is governed or falls within those number 1 and 2 categories? So the easiest there with these regulations is the mayor order, the orders we're getting from city mayors, because those are really, hey, everyone needs to stay at home, shall stay at home. More what we would call a quarantine or isolation, what we think of. So those are clearly covered under the regulations. With Governor Stitt's order, one of his earlier orders was that any person who either has a vulnerable persons, meaning you have an underlying condition or you're over a certain age, shall stay at home or shall shelter in place. And the regulations specifically address those orders, and they say those orders do qualify as a quarantine or an isolation order.
You're talking about for the vulnerable people, question.
For the vulnerable people, no question about that.
Okay.
Right. And then, then you have the issue of, like, Governor Stitt issued an order saying all non-essential businesses are closed, right? And so those employees are not to come to work. And whereas the regulations don't specifically address that issue, the regulations make clear that these different categories are triggered if an order prevents somebody from being able to work. So I think pretty clearly those fall in, Governor Stitt's orders fall into that category.
Excuse me, go ahead.
Yeah, because the employee is not able to work because of the governor's order related to COVID-19.
Okay, so the governor's order and related mayor's orders, they accept from that essential businesses or critical businesses. So what about employees who work for employers that have been recognized by the government as essential or critical? How does that impact whether or not they're entitled to paid leave?
Yeah, and I think based on the regulations, it's clear that those individuals are not entitled to paid leave based on the governor's orders. And the reason being is the regulations state that the person has to be, unable to work because of the orders.
Right.
Well, if the governor's orders permit you to work, then you're able to work and you don't fall into either one of those qualifying events.
Now, one thing we want to make clear for our viewers is even if you're an essential business, if you suffer from your own COVID-19 symptoms, or you have personally been ordered to self-isolate or fall under any of those other categories, you still may be entitled to paid sick leave, correct?
Correct. This is just addressing the whether you're entitled to paid sick leave because a government entity has issued a broad order for people to stay at home.
All right. Now, one of the things, Jake, we've been facing with employers are instances in which an employer has laid off or furloughed employees by virtue of either the governmental order or just the downturn of business. Do the new regulations address or require the payment of paid leave to employees who have been laid off or furloughed?
Yeah, and that's a really good question. And the answer is no. It does not. The regulations make clear that an employer who has laid off an employee or furloughed employees does not have an obligation to pay that person. And the reason being is one thing the regulations really set out that the Act didn't address is that, in order for a person to be entitled to paid leave, there has to be work that the employer has for them to do that they can't perform but for one of these qualifying events. So if the employer has no work for the person to perform, then they're not entitled to paid leave.
So let's go with three specific examples. The first example, when an employer has laid off or furloughed employees by virtue of the governor's order or mayor order, they've been furloughed. Are they entitled to paid leave?
They are not entitled to paid leave. The regulations specifically state that.
All right. What about employees who have been laid off or furloughed after April 1, April 1 being the effective date of the Family First Act? Employees who are subsequently laid off after April 1 or furloughed after April 1, are they entitled to paid leave?
Yeah, they are not entitled to paid leave from the moment that they are furloughed or laid off. And what I mean by that is, let's say you have an individual who takes paid sick leave for one of these qualifying events, and they're on sick leave for, let's say, 5 days, right? So they haven't used all of it up. They're still in their 2 weeks. But the employer comes down and lays off a group of employees, and that person is included in that. Well, at that point, the employer would have no more work for that employee. So that person, while they may have been entitled to paid sick leave for the first 5 days, would not be entitled to any more paid sick leave after that.
Okay, so you've anticipated my third question was instances in which employers have begun paying paid sick leave or have begun providing expanded FMLA leave, and after that, they are laid off or furloughed. In the midst of that, does that mean that paid leave will cease at that point?
Yeah, it will cease, and at that point, and even to go back to your second question, after April 1st, before April 1st, from the viewpoint of the regulations and the act, it really doesn't matter when the layoff or the furlough happens. It's still the same impact, which is a person laid off or furloughed is not entitled to paid sick leave after the layoff or the furlough happens.
All right. Kathy, let's turn to teleworking or remote working, which is becoming increasingly common with these circumstances. Whether an employee is entitled to pay leave may determine or depend on whether the employee can work remotely. Can you explain under our new April 1 regulations how teleworking comes into play and how it works under these new regs, please?
Okay, first of all, we have a good definition of what telework is. So telework is work that the employer allows the employee to perform at home or at another place other than normal workplace. So you're able to telework, number one, if your employer has work for you. Number two, the employer allows you to perform that work from your location, whether that's home or another place. And there aren't any extenuating circumstances, such as you're suffering from COVID-19 yourself, that would prevent you from actually performing that work. You can perform telework during your normal business hours or at other hours that you and your employer agree to. But it's basically what you and I would normally think of as work that is subject to payment pursuant to the FLSA. An employer can't avoid its obligations to pay for work simply because it's being performed someplace other than the workplace.
Well, and I think we're seeing and dealing with a lot of our employers that we work with, they're becoming very creative and willing and receptive to trying more remote work. One of the things I'm running into are instances in which someone is not working because their child's school is closed or their child care provider is no longer available. Is teleworking an option that's recognized by these regulations when someone is involved in those child care responsibilities?
Yes. I mean, it can be, if you're completely unable to work because of your child care responsibilities, that's one thing. But if you're able to work at different hours of the day, for example, you can work in the evenings or early in the day, or maybe you and your employer agree to a schedule where you work certain hours, then that's allowed by these regs. It's intermittent, but it has to be something that your employer agrees to. It can't just be something that you decide to do on your own as an employee.
So one thing, employers may run into situations, they may have a situation where an employee is going to say, I'm not capable of working remotely because of my child care responsibilities. And I guess that could be an extenuating circumstance, correct?
It could be, yes.
Okay. And alternatively, you could have a situation where maybe you have two parents that are trading off, and the employer may want to work arrange for and agree to intermittent remote work, and that's up to the employer whether they agree or not agree, correct?
That's correct. The key is the employer has to agree.
Okay. So, one thing to keep in mind, there's nothing wrong on any kind of remote work to try it on a trial basis. I mean, you may be pleasantly surprised. It may be more successful. If it doesn't work, you're not penalized for saying, this is not working, it's not being effective, and we're gonna cease that. So, we encourage you, if it makes sense from a business standpoint, experiment with that. Take a trial run, see if it works, because it's ultimately up to your decision of whether you're going to be able to make this work for you and the employee. And that's another example where communication and transparency, Kathy, as you point out, is very important. Jake, we have some overlap between the paid sick leave and the expanded FMLA leave, because an employee, as I understand, who's caring for a child may be entitled to both the 80 hours of paid sick leave, and by virtue of the expanded FMLA leave is also covered in that category. Do the DOL regs explain how these two interact, the 80 hours of paid sick leave and the expanded FMLA leave when we're talking about childcare issues?
Yeah, so the regs make clear that the purpose of the act is for, the paid sick leave and the FMLA to complement one another. And what I mean by that is those first 2 weeks of emergency paid sick leave because of childcare issues, the act makes clear those can run at the same time when someone starts their FMLA leave.
Okay, and so incidentally, the first 2 weeks of FMLA leave is unpaid, correct?
Correct.
So that 80 hours, how do you see that working in that circumstance when you have the overlap?
Yeah, so the way I look at it is those unpaid leave, 2 weeks under the FMLA, the 80 hours of emergency paid sick leave is going to essentially step in during those 2 weeks of unpaid leave under the FMLA.
Okay. And what if an employee has previously taken FMLA leave for a non-COVID reason? Let's say I broke my leg and had 4 weeks of FMLA leave previously during my standard FMLA 12-month period. How does that interact with the fact that I may be entitled to both that paid sick leave and the expanded FMLA leave?
Yeah. And so, one thing the regulations make clear is that an individual is only entitled to 12 weeks of FMLA, whether that's 12 weeks of, non-COVID unpaid FMLA, or 12 weeks under the expanded FMLA. So if you've already taken 4 weeks of FMLA for a non-COVID reason within the 12-month period, then that means you're only entitled to another 8 weeks of FMLA under the expanded FMLA.
Okay. Now, in one of our earlier videos, we pointed out that employees they have the ability to use their accrued, unused paid time off or vacation to make up the difference between what they're going to receive in paid sick leave and what they're going to receive in expanded FMLA leave, so they can bring it up to their total regular wages. Do the new regulations maintain that right for the employee?
They do, and they actually confirm that is an option an employee has. You're talking for that extra 1/3 pay.
Correct.
Right. Yes, that an employee has that option. They can't be forced to do that, but they do have that option.
All right. Let's talk about notice. Do these April 1 regulations, Jake, do they tell us what sort of notice an employee has to provide their employer that they may need family first paid leave of some sort?
They do, and there's kind of two different scenarios where it talks about notice. The first one in the regulations is talking about if someone needs notice or someone needs leave for childcare issues, right? And the notice says they need to provide notice or the regulations, say, hey, that person needs to provide notice as soon as possible. An employer is allowed to require that. But let's say someone needs leave for any of the other reasons. The regulations say an employer can require what it calls reasonable notice, and reasonable is based on all the different facts and circumstances of that specific employee or that business. Does say that you can require them to give notice, but you can only require them to give notice after the first day that they have a need to take leave.
Okay.
Right.
Do you have any thoughts or recommendations to our viewers on what an employer should do about letting their employees know that they need to give notice of potential paid leave?
Yeah, I would first I would put it in a policy that you're going to send around to everyone now, right? Don't wait for somebody who actually needs the leave before you decide how you're going to handle it or what notice you're going to require. But then I would put in there that, hey, once you have a need for leave, notify us as soon as possible. And within that, I still think you have to have this idea of leniency a little bit with as soon as possible is going to depend on each situation.
Right.
Right. So, and the regulations do talk about that if an employee fails to give notice, that the employer should go to that employee and say, hey, you haven't given us notice, tell us what's going on. Right. So it's not intended to be, you didn't provide us notice, you don't get leave, you're going to be disciplined. It's not really intended to be applied that way.
One thing we're working with employers quite frequently these days, particularly when you have a workforce now that may be dispersed, people working remotely, people not working non-traditional hours, it's hard to get messages across. We're putting together policies or announcements. Again, part of the role as an employer, I think, is informing people what their rights are and what they're not. There's a lot of misinformation right now on what paid leave people are really entitled to. So I think it's really beneficial if we can give employees a written description of whether and how they're entitled to leave, and the kind of notice provisions you're talking about, Jake, I think are very effective. Again, Kathy's point, very transparent. Jake's point, let's communicate. Let's let people know. It's a little bit more challenging if everybody's not 9 to 5 in their office or at their place of work or in their factory. But let's get that communication out. Let's get that transparency out. Kathy, employers have been struggling with what sort of information or documentation they can request or require from an employee. Jake talked about giving notice, but do the new regulations give us any direction or establish what an employer, once they get notice of someone's need for paid leave, what sort of information or documentation they can ask for an employee to prove entitlement to paid leave?
They do. However, as Jake pointed out, for folks who are used to administering FMLA on a regular basis, it's not going to be that kind of documentation. It won't be that strict. For example, before an employee takes paid sick leave or expanded family leave, an employer can ask for things like reason why the leave is requested, the qualifying reason for the leave, and can ask for an oral or written statement that the employee is unable to work because of the qualified reason for the leave. So that's the initial information gathering, the initial notice that the employee provides to you, and that is different than normal FMLA, where we would require the forms to be filled out and to have some sort of certification from a healthcare provider. However, before I forget, we are awaiting some forms from the DOL that would give us a little bit more guidance here. If I need to take leave as an employee because of a governmental quarantine order, then my employer can ask me about, what governmental entity has subjected me to a quarantine. If I need to take my own sick leave, my employer can ask me to provide the name of the healthcare provider who advised me to self-quarantine, for example, because I have COVID-19. And the same is true with respect to somebody who I'm taking care of. For employees who need to take leave, sick leave and or expanded family medical leave because of childcare reasons, the employer can ask the name of your son or daughter, the name of the school, the place of childcare, or the childcare provider that's closed or become unavailable, and can ask for a representation from the employee that there's no suitable person who can care for the employee's son or daughter during the period of time that the employee needs to take the sick leave or expanded family medical leave. And then finally, there's a bit of a catch-all where the employer can ask the employee to provide additional material that may be needed for the employer to support the employer's request for tax credits under the Family First Coronavirus Response Act.
Well, I think it's significant that the regulations recognize that there are going to be circumstances where we're just not going to be able to get documentation from healthcare providers. I think the regulations emphasize that employers have to be realistic. They have to be reasonable in applying this. And as we've said, transparency towards their employees and, frankly, leniency, unless we feel like someone's abusing these provisions. Leniency and transparency are very important here. I want to thank Kathy and Jake for helping us today to continue to update employers about new COVID developments and provide answers to you as they become available. Again, we want to encourage you to use our COVID-19 response page and resource on our McAfee and Taft website, where you'll find the latest in information and recommendations for businesses. We want to encourage you to subscribe to our COVID alerts. Again, that's a way in which we hope to keep you advised as we learn new information and as we find new information, because we're committed to providing advice as this changes, as new information becomes available. We're keeping up on this on not just employment issues, but benefit issues, tax issues, and business and loan issues. Please, if you need it, please feel free to contact our COVID-19 response team, which you'll find on our website. We're available to answer any of your questions. In the meantime, stay well and treat one another well. Thank you.